Right. So we can discuss today's shareholders and their life. Probably. Shareholders and their life. Online people, can you hear me?
Yes, sir.
So now Sri Lankan companies, even though companies incorporated to sell chocolate, we can sell fruits. It is clear now. However, if it is not done according to the law, directors may be liable. Directors may be liable. Because generally, articles are drafted by the state. Even though it's not drafted by them, they have a duty to compare, to understand and work according to the article. Therefore, they may be liable, so it is good. But it does not affect the third party. According to the Ashwell case, long time ago, even the judges believe that before you dealing with the company, you have a duty to go through the memorandum and articles and so on. So it is not practical at all. So now you don't need to. Okay, today we discuss about the shareholders and their shareholders and their. Any shareholders? No. Don't even try to buy some shares. But the business is good. Out of the class, there's no any shareholder of the class. So we have 60%. Probably some microfinance company. That correct? Because interest rates are also now low. So people go for that behind the microfinance companies. So do I. This you pay 26, 28. So high risk, high return anyway. But is there any relationship with the Colombo stock exchange and students? You want to look that? We have one session with the CSA. And we have one session and we'll discuss about the CSA rules regulation and also with the state cap, right? Also, maybe we could go there, but they also have the auditorium and all. Probably they have some money allocated for education and promoting. So you could go there and have some let's say in their process. We'll arrange that as maybe part of your training. So sometimes you can get some reasons behind our stock exchange, why it is in this way. Not because of Corona, I think even before Corona, we probably may have good stock exchange. We are in some countries, there are more than one stock exchange. They have also planned to go public, but I don't know what happened. This Galle company, associated company, they have done all the things to make it a public company, but even I don't know what happened. But sometimes there are some type of things that you can learn there. Right? I knew that one time, NDBO, I think they have issued shares, same share for the two different prices. Even I was shocked. Realized that, right? The same original shares, they have issued for two different prices. Say 130, 125. Right? But after that, we only know the traditional reason to issue different types of shares, right? What do you think the reason? Maybe not after that, right? Don't share price there. Right. It was probably an initial issue, I think, right? So probably they have no idea about the price and they want to sell it for a higher price, but they before they have mentioned the same share for two different prices, plus they will allot the higher price. Therefore, probably they expect for the people to ask for the higher price. Probably they expect. If they really want, they will go for a 30 rupees. They will allot first for the 30 rupees share, and if there is any balance, then only they will allot for the 25 rupees. That type of things are also discussed. So we discuss it under this topic. For those things, anyway, we try to have discussion with the CSC people as a guest lecturer. So we will discuss the basic shareholders and their rights. So who are the shareholders? As you know, shareholders are owners of the company. Anyone who pay, shareholders are the owners of the company. But this ownership is completely different type of ownership. Right? You cannot compare the company ownership with the ownership of other type of business. As an example, if you are a sole proprietor, the properties of sole proprietorship is belong to whom? They belong to the sole proprietor. Or if you are in a partnership, the property of the partnership belong to whom? They belong to the partner. They are the owners of the partner. If you are a shareholder, so properties of the company belong to whom? Yes. Company's property belong to whom? So they do not belong to the owner. So that is why I said this is a different type of ownership, right? They don't belong to the owners. They belong to the company itself, because company is a person who can own its own share or property, so whatever, right? So company's property, they don't belong to the owners. Therefore, as owners, they don't belong or they don't own any assets or property of the company. And even they cannot, the sole proprietorship, your sole proprietorship, you manage, you control. So that's your partnership. But in company, we have shares with you. You even don't know who are the directors, the public companies, right? As owners, we have no say in management. Management is done by the separate small body called board of directors. So what is this ownership? They cannot manage the company, they cannot be involved in the management, they have administration, right? So they don't own the assets of the company. So that is why I said complete different type of ownership. We traditionally say they are owners, right? But as long as I can make you more complicated if you want, right? Say as an example, even though we say they are owners, right? They will be owned if there's a in a high income, if there are any surplus assets, hopefully they will be belong to the owners. However, that is also only in the solvent company. If the company is insolvent, then who has more rights in the company? Owners of creditors, shareholders of creditors. Right? Insolvent companies in fact belong to the tenant. Right? Shareholders are owners of the companies only when the company is sold. Right? Insolvent companies belong to the tenant. Right? In any company law or any liquidation rules, when the companies are insolvent, creditors have more rights than the shareholders. Right? Therefore, that is also not true, right? The company's owners are shareholders only when the company is a solvent company. When the company is insolvent, in fact, it belongs to the state. Right? Therefore, this is a very different type of ownership. Right? So we try to the law related to this ownership, right? Because what they do own. Some people say they only the owners or shareholders, they only provide the capital requirement for the company. Some people say they just it's just a method of investment. Right? Some people say as owners, they only have a piece of paper, known as the certificate, so the share certificate. If it's a listed company, even they don't own that. Right? So they are also very different type of owners, even though we traditionally say they are owners of the company. So in law, what we can say is that as owners, so they have some rights recognized by the Companies Act. Those some rights are in fact attached to their share. Some rights are recognized by the company law and common law. So as a shareholders, if those rights were breached or broken, then through courts, they can effectively enforce those rights. In fact, that is what legally the shareholders say. right? So there are some recognized, well-defined rights, right? So if they were reached to a broker, then those as a shareholder owners, they can enforce those rights effectively through court. If that, I hope that is what they do as a shareholder. Otherwise, sometimes some people even don't know whether they are individual holders or shareholders. Right? Now, some people they don't know, but they are owners, they are creditors, but I don't think in really those business people or investors, it is a matter for them whether they are individual holders or shareholders. So some people get those advantages anyway. The best example is the BOC. Right? If BOC issues shares, what will happen? So they got some whether they have really, but only few knows that they have issued debate. So traditional people believe they are different. They are owners and creditors. But we'll also discuss on this topic between the shares and the creditors. Okay, so those are things that we're going to discuss under this topic, right? So we'll discuss the meaning of a shareholder, their rights and obligations, the liability of shareholders, how do they exercise their powers, the different type of resolutions that they can pass, and how to alter the shareholder rights. And yes, we also will discuss what is known in terms as majority rule and minority protection. And the minority protection, we're going to discuss some sections relating to oppression, mismanagement, restraining orders, derivative action, and minority buyout right. So those are the rights that I mentioned that they were broken. This as a shareholder, they can enforce those rights too. Okay. So we try to go through one by one. One of the purpose of passing this law in 2007 was to one main reason is nothing but to simplify the incorporation process. So what do you think about that objective? Is it achieved or not? We have discussed the incorporation. One main reason to pass this law to simplify this legislative process. Is it achieved? Probably it is done. Now anyone can incorporate a company within a day in Sri Lanka. So that is good enough. Before this law, it took at least 2 weeks, maybe 1 month. But now within a day, you can incorporate a company, can do at any place, any time, right? Any day, right? Even when you are in another country, still you can incorporate a country in Sri Lanka. So it is almost done, right? No physical incorporation, no requirement of memorandum. Right? Only document is the articles. That is also provided in the model article. So even that is simplified. Even one person can incorporate a company, right? Even you can enter contract before incorporation, right? So what else? So probably it is achieved, right? So you don't need to go behind the lowest and auditors or accountant to get your company incorporated. You all can get it incorporated. So therefore it is achieved. Another reason to pass this law in 2007 was to define or catalog some terms or rights. As an example, who is the director? What are the duties of directors? Who is the shareholder? They were not being cataloged or written before 2009. But now there's a meaning for the term director. Directors' duties are now cataloged. The term shareholder is defined. Right? So that is done with this time. So there were no clear meaning for the term shareholder before 2007, but this act again, there's a definition for the term shareholder. Before 2007, even though there's no definition, it was almost there. There were shareholders, they find paper, the court recognized it, right? So basically, there were 2 ways traditionally to identify a shareholder, right? There were 4 methods to identify a shareholder before 2007. So those methods were by becoming an initial shareholder. Right? So if you are a signature to the Form 1, then you are a shareholder. Or if your name is there in the amalgamation proposal or application form, then you are a shareholder. Right? So initial shareholders are shareholders of the company according to the transition law before 2007. And also by creating up an allotment of shares issued by the company, right? When company issues shares, you can apply. If your application was accepted, then the company will allot shares for you. By allotment, you can be a shareholder of the company. Or by transfer of shares. Right? If A transfers shares to B, by transferring the shares, the B can become a shareholder. Or by transmission. So we use the term transmission to mean by operation of law. Right? I have a shares upon my death, my next of kin will be a new owners of the share. Right? So those are the traditional methods of becoming a shareholder. Almost all those methods are there under the 2007 Act as well, but it is more clear. Right? It is more clear. So now there is a meaning for the term shareholder under section 86. We have a company that we can put section 86. It defines the term shareholder. So before reading 86, but you need to understand, I think, what is meant by the share register, right? So there are some registers which is required by law to be maintained by the company. One of those registers is a share register. It is a law that all the companies are required to maintain the share register. So share register is a register which includes all the name of the shareholder. It must be registered and must be kept at the registered office of the company. If a company has more than 50 members, they are also required to have an index register. That is again the same thing, but names according to the alphabetical order. Right? So there is a law to maintain the index register and the share register. Okay. So this section says if a person's name is in the share register, he is a shareholder. Simple name. Share register ke shareholder. Right? It's a law that all the companies maintain. Some private companies don't do, but they have. And then it gives an extended meaning for the term shareholder. So it says sometimes, yes. Sometimes maybe the newly incorporated company may not have a share register. Right? Or maybe their share register does not include the name of the people or initial shareholder. In such a case, though, say, if a person's name is there in the application form or amalgamation proposal, even though their name is not in the share register, they are also shareholders. The traditional meaning of linked. Sometimes initial shareholders' name may not be in the share register. Company may not have a share register. But those people, if their name is in the application form or amalgamation proposal, they are also shareholders, even if their name does not appear in the share register. or if a share has been transferred, right, A has transferred his share to B, but is still in the share register, A's name is. Share register, but this already been transferred. So if it also has been transferred, then the law says the transferee is also entitled to have his or her name in the share register. So he is also shareholder. So that's the meaning given by the Act for the term shareholder. So accordingly, shareholders are the person whose name is in the share register, or the person who is entitled to have their name in the share register. Who are entitled to have their name in the share register include initial shareholders whose name is in the application form, or initial shareholders in the amalgamation proposal, where their name appear in the amalgamation proposal, or the transferring of the profit. A person transfer their shares to another person, but still they are not in the share register. But those transfers are also entitled to have their name in the share register. So those are the meaning for the term shareholder under the 2007 Act. That almost cover almost every traditional meaning for the term shareholder. Right. So anyway, that will be said that shareholders are the owners or proprietors of the company. Right. Even though they are owners, now we well aware that they don't own the property of the company. They have no power in managing the company. Right. And in fact, they are not the owners when the company is insolvent. Right. So probably they provide the capital requirement and return, they become the stakeholders of the company. So that is even that are they entitled to get it back, their investment. So you invest in the shares, you bought some shares, now some person back up to another such a situation. Are you entitled to get your investment back? No. There's no provision in the compressor or no such a tension, no common law rule. There's no such a rule, right? If there is a profit, you will get dividend. Right? If there's a surplus asset, it's belong to the shareholder. But if there's nothing left, then there's no guarantee at all. It is there for the creditors. Right? You're only eligible if there is a surplus after paying off all the creditors and other expenses. So there's no guarantee. So that is why share market is created, but you can trade your shares in the share market. Right. We also try to understand the right of shareholders and their liabilities. So where are the, or what document include the rights and obligation and duties of shareholders? Yes, articles of association. So generally, their rights, obligations are, they are in the Companies Act and mainly the articles of association, and also may be decided by the common. Right. So the rights and obligation of shareholders and even the directors. So they are mentioned in the Companies Act, articles of association, and by the common law principle. So they enjoy all those rights and powers given by the common law and all subject to the Companies Act. Right? They are subject to the Companies Act. So most important law is nothing but the Companies Act. That's the principal act, right? So thereafter there's a articles of association. We already know article is a contract. It's statutory contract. If there's a breach of the contract, then the company can sue against the shareholders. Other shareholders also can sue against it, right? So, and yes, and also it is decided by the common law principle. There are some established principles, and also there may be some individual, that also decide their rights obligations. There will be some individual agreement between the company and shareholder. So, according to the Act, it covers rights and obligation of shareholders under three parts: the liability of shareholders, powers of shareholders, and under minority buyer rights. So we're going to cover this all. So, however, under the rights of the shareholders, there are some rights which are unfettered and attached to the shares. So they enjoyed by the shareholders. Those rights are traditional, unfettered rights which are attached to the shares of the company. So they include, you all know it, right to vote, right to dividend, and right to surplus assets and dividend of money. So those are the daily rights of all the shareholders. Right to vote, right to dividend, and right to surplus assets and liquidation. So they are the traditional right for all the shareholders. What about the liability of shareholders? Rights we will discuss in detail. They are liability. Liability is limited. Who said? You. Generally, shareholders' liability is limited, so we can accept it. Right? But if the company is unlimited company, then can you be the same answer? Then the shareholders' liability is not limited. Therefore, shareholders' liability is limited only when the company is a limited company. When the company is unlimited company, then you can't say that shareholders' liability is limited. Then their liability is unlimited. And if the company is a guarantee company, then their liability is limited but differently accepted. Next, different. In the guarantee company, their liabilities, they are only liable to pay at the end of winding down, whatever the amount they agreed to pay. But as a shareholder in a limited company, they are liable to pay on calls. Right? And they are liable to pay on calls. But guarantee company, they are only liable to pay at the end of winding. Right? Guarantee company gave a Wahala a limited company, they are liable to pay on calls. Therefore, liability is different. Therefore, even though you say the liability of members of a company is limited, in other times, now it is not as it is because that depends on several factors. Mainly the liability of shareholders or members depend on the type of company. If the company is a limited company, then only shareholders' liability is limited to the shares they have bought. But if a company is an unlimited company, they have unlimited liability. If a company is a guarantee company, then their liability is different. Even the companies between private and public company, we all know the liability is different, right? The public company, their liability is towards the number of the stakeholders, right? Maybe at the end, even to the environment. But in the private company, their liability is probably for those privately owned people only, right? Therefore, their liability is clearly, right, decided according to the type of company. And also, yes. Right. But yes, liability is limited. When the company is a limited company, that is even recognized by Section 2 and Section 87. Right? Section 87 says the shareholder shall not be liable for any act default obligation of the company by reason of only being a shareholder. So that is related to the limited companies. For the limited companies, their liability is limited. Right? Because we all know companies separate, shareholders are separate. Therefore, shareholders are not liable for the act of the company. So, for the company's act obligation before, company itself is liable. So, their liability is limited according to the type of company. Their liability is limited according to the Companies Act and the Articles of Association. Their liability can be also decided according to the type of company. Unlimited company, share company, So there are some shareholders may have some individual contract with the company. Some shareholders may be employees. Some shareholders may be suppliers. Right? Then according to the agreement, again their liability differently applied. Right? If one shareholder is a CEO, right, or managing director, then again there is a different liability. Right? So their liability is also decided according to the individual agreement the company and the shareholder has. Right? Also, if they have done some reckless negligence act according to the dealing law, right, they will be liable for the company. As an example, as a result of the shareholders act, if it effect for the decrease of the shareholders' value, right, or maybe some of the statement in the prospectus, right, if it affect the company's image, right. So sometimes those shareholders will be liable for the company for their reckless negligence act. Right. Therefore, shareholders' liability is decided basically by the company law and the articles of association. And also, we can widely accept that shareholders' liability is limited when the company is a limited company. However, exactly their liability is decided according to the law and the Companies Act, and also according to the type of company, and also according to the agreement they have with the company, and also according to the delictual wrong they do with the company. Right? That all will decide the liability of shareholders of the company. Right? Therefore, we simply cannot say their liability is limited. Right? The company is limited, then it is valid. These are maybe a little bit more complex for you, but just you know, but if you don't understand, forget it, right? For a lawyer, and they were. Killing shareholders' liabilities, yes, if the share is not paid, who is liable to pay? Really, nowadays, those are not widely accepted because almost all the shares are fully paid. Not fully paid. But there will be some shares like private companies, they are not paid. Private companies are not fully paid or not paid at all. Public companies are almost fully paid. Nothing issue there. But those laws are there because at the very beginning of the company law, partnerships were more popular than the company. Therefore, companies actually have to pay later. Therefore, there were some shares they were not fully paid. So then who is liable to pay if it is not paid? So basically, it is believed that the current shareholder is liable. The current shareholder is liable. But there are some issues related to the issue price. Issue price. Okay. So, for the issue price, right? So those issues are there basically in liquidation. Winding up of a company. Say now company issues shares to the initial shareholder A. Now he has transferred them to B. B has transferred them to C. Okay. Now basically C is liable to pay. But if he does not pay, if he is not in a position to pay, then in the winding up only, the liquidator has a right to file a case against the initial share. Right? It is only the liquidator, right? So therefore, it is an exception. Basically, the previous shareholders are not liable. Even after 6 months, they are not considered as shareholders. But still, liquidator can file a case against the initial shareholder if they were not paid, but only at the event of winding. But that is also related to the issue price. That is justified by law because it is the contract is between for the issue price, the contract is between the company and the customer. That is the other contract. Therefore, he is liable to pay the issue price. Even though he has transferred the shares to Lanka, but the still contract is between company and that person for the issue price. Therefore, he is liable to pay the issue price of the company. Therefore, sometimes even though you have transferred the shares, if the company does not function properly, right, as initial shareholder, still that person may be liable if company does not properly multiply. So the issue price there may be still liable. But under Section 89, I think we have discussed that earlier as well, right? Sometimes we all know the shareholders' liability can be increased. It can be increased by passing resolution or by altering article. If it is increased, whether shareholders are liable to pay that increased price. We have discussed that on the articles after, right? Basically, when there is articles of association, so you cannot break. If the company alters the articles to increase their liability, then are they still bound by that altered article? Right. Section 89 says, Section 87 says the shareholders are not liable, right? However, under the articles of association, which is a contract, they are bound to honor that contract. However, if the company alters article, right, and if the shareholders have voted against that alteration, then they are not liable by altered article. Because the law accepted that the company cannot increase their liability without their consent. Therefore, if the company alters its articles to increase their liability or pass resolution to have more liability or increase their liability, unless those shareholders have given their consent in written, they are not liable for altered or amended articles. Therefore, company cannot increase their liability without their written consent. So that article is not a contract. If they have agreed, then they are liable. Right. Now, company's power is divided between two groups, mainly board of directors and the shareholder. That is to make or to have more democratic business. Because if all the powers are given to one party, so what will happen to the country will happen to the business area. Right? So that is why, but that is what business and country almost same in this sense, okay? So, but at least in theory it is divided between these two. Some powers are given to the shareholder. Some powers are given to the board. Like country has divided, government has divided into three names: legislature, executive, and the judiciary. But nowadays there are issues. And like Srilanka. There's only one institution, or whether we have three over. Because of the wide powers of the executive. We can clearly influence the parliament because our parliament, the most important members of the parliament is the cabinet. So they are elected by the president. So he can clearly control parliament with them. In parliament, powerful people are the cabinet ministers. So they are appointed by the president. In America, the president cannot influence the parliament, right? Yeah, staff is different. Congress members can be a staff of the president. Completely different. They go like a secretary, they can be selected from the Congress. They selected, they can have resign from the Congress. So it's separate. But in Sri Lanka, they are cabinet members while they are the members of the parliament. Therefore, the president clearly can control the parliament. And very recently, very unfortunately, now they also influence the judiciary. It's a very unfortunate situation in Lanka. Times by negative, right? Now it is openly happening. The recent case was one of the judge of Murati was resigned and left the country. They are not uncommon in Sri Lanka. The judiciary cannot take anything at the right? So that is what one power is with the one part. Right? So that is why tradition, right, they have divided between two groups. That is why government is divided into all the democratic countries. Government is divided into three parts at least, as executive, legislative, and the judiciary. Some part, some also now recognize media as also one part there. Then someone media has our part like there some other thing, right? Lanka and the media, right? Actually, in the country, the media is controlled by the politician, right? Anyway, so likewise, even in the company, without giving all the powers to one party, at least these powers of the company are divided between these two. Some powers are given to the shareholders, some powers are given to the board of directors. As an example, here it is obvious that day-to-day business is governed by the board of directors. But it doesn't say that they have a discussion to get anything done. As an example, who will appoint the directors? Directors appointed by the shareholder. Right? Who can remove the directors? Shareholders can remove the directors. So likewise, they need to get the support of the shareholder. Right? The directors cannot enter the major transaction. It has to be approved by the shareholder. Right? So they cannot reduce the special capital. It has to be come from the as a special resolution of shareholder. At least the directors can change the article for name of the company. They have to come from the approval of the shareholder. Therefore, some of the business are given to the shareholder. Right? Without their support, the board cannot get them done. Right? One of the best way of controlling directors are appointment powers, removal powers, and their remuneration. Right? Their remuneration salary, directors themselves cannot decide. It has to be approved by the resolution of shareholders. So those are the ways that the shareholders, owners can control the right powers of the director. But in practical, it is not the same as I explained, right? Mankina Vagina practically. How the board to keep it? May the shareholders are the board members. May the shareholders are the board members. So as the shareholders, they will get their own salary as they wish. So only 51% shares belong to one family or one group, or maybe one person. Therefore, as the shareholders, they approve what they want as a board of directors. Therefore, in practice, it is not the same, but at least there is a law. At least there is a law that satisfies there is a requirement of special resolution. It is not, you can't do some material business with the majority of 51%. For that, 75% requirement is there. Where in public companies, 1% cannot have 75%. Therefore, definitely they need to for that. Therefore, there are some material business which require to approve by more than 75% of voting. That is good. Right? But 51% probably is not such a democratic thing, but that is known as the democracy. Majority. 51% in the majority. Democracy is that is our parliament. Parliament is the by India. It is that. Right. Simple matter. Then they can not do this. President that thing, 51% not told me. 50.1 that he will be the president. Maybe 49 against him. But still he will be the president. That's the democracy. Right? That is the majority rule. People live by different countries. Then America got the probably has very in Sri Lanka, all the countries consider as one electorate, in president election. In America, everyone came with an complex situation of me. The Mangitan name. You need to call it. Here I call the look at the other. You didn't something like that. Yeah, that's good. You didn't know how to read that. Very cool. Electorate. That's not very good electorate. Regular Mangitan, Washington will be more than 2 years. Attack with the Rimado, how do you again? something they can see and they see it. This is a very illustrated, right? A absolute president of the is percentage. Very illustrated one I got it. The Sandipuram I got it. So that is American law, right? Therefore, there are different meaning for the democracy. Democracy, right? Right. So, anyway, income is also run according to the democracy. So, company's power also divided, management also divided between shareholders and the board of directors. So, some powers are given to the shareholders as owners, some powers are given to the board of directors. With the support of both of them, they will run the affairs of the company. Right? But as I said again, even though we said that they divided, but in practice, almost major shareholders become the board of board. Right? Therefore, they will get whatever they want to pass as the shareholders at shareholders meeting, and at the board meeting they will get it done. Right. So, however, so those shareholders, how do they exercise their powers? So shareholders exercise their powers at meetings, passing resolutions. So that is how they exercise their powers. So they exercise their powers at meetings, passing resolutions. Those resolutions may be, what type of resolution can be passed by the company? Only resolution, right? Special resolution. Those are the two popular type of resolution. This act recognizes another type of resolution known as resolution in lieu of meeting, right? Sometimes known as the breaking resolution. Actually, I will pick up again. We will discuss. So basically, that breaking resolution is also maybe either voting resolution or special resolution. It is only a way of passing. Without having meeting, now companies can pass resolution. But generally, traditionally, companies pass resolutions at meetings. Meetings will not command that you can pass. Shareholders are ordinary control right? So this is the two methods that they can control shareholders: their appointment, their removal, their termination. It has to come from shareholders. Directors can do that. Another way is that in company law, there is no any section of the company act or common law rule or tradition that the board has to follow the instruction of the shareholder. In fact, there's no rule at all that board has to follow the or has to act according to the wish of the shareholder. And also they don't do, and which is not illegal. Ek kisima illegal ගතියක්වත් unethical ගතියකුත් නැහැ. According to the company. Because as a business people, they should have freedom to run the business. The only requirement is, as a board, they have to act according to the company's act and the article. But they are not bound to act according to the wish of the shareholder. There's no such a thing like company. Once appointed as president, they are only bound to act according to the constitution, not according to the wish of the citizen of the country. එහෙම එකක් නෑ. ඒකද කරන්නේ. නමුත් ඉස්සෙම constitution එක ගන්න තමයි වැඩ කරන්නේ නේ. කණින් වැඩ කරන්නේම constitution එක. Right? So they are only bound to act according to the constitution නේ. පත්තුනේ constitution එක බලනනේ. වැඩ කරන්නේ constitution එක. So that's their responsibility, right? So they are not bound to act according to the wish of the citizen. Even in the company, board is not bound to act according to the wish of the shareholder. They only bound to act according to the company's act and the articles of association. But shareholders can alter the articles. In that way, then they can control the board of directors. one of shareholders have put on, right? They can order the articles of association. And everyone put on 10 million borrow and abandon. If there's such a clause in the articles, then the directors they don't need to follow the wish of the shareholders, but they are bound to follow the articles of association. If article says they can go more than that borrowing, then they are bound by it. Right? Therefore, that's another way that shareholders can control the board of directors. They can alter the articles. Then the board are bound to act according to the articles of association. Then because at least before 2007, there was an object where they are bound to act within the object. Now there's no object clause in some complaints, right? The directors can do any business, right? If there's object clause, at least they are bound to act within the articles, right? 75% special resolution have passed that they can go, but otherwise they are bound to act within the articles, otherwise the breach of their duty. However, if there's no object clause, then directors can do any business. And also before 2007, directors' issue of shares is limited to the authorized capital. Before 2007, there was something called authorized capital. That is the maximum number of shares the board can issue. But now there's no such a thing. Right? Directors can issue any number of shares. So therefore, now directors have very wide powers, but I try to control it nicely. But anyway, their powers are really wide too. So they have a very wide powers as the board of directors. So that is why even in Sri Lanka, you always try to amend the constitution. Right? The constitution is amended, then they are bound to act according to the constitution. So all the presidents or elected or candidates came to power in Sri Lanka to amend the constitution. Okay, but no, it was done to some extent, but it was more. Mahinda Tilo Mangila Parasta. Parilut Kina Velasco. Ila Parateno Velasco. Right? Sure. But never done, never will. Kamala Velasca, Kamala Velasca, President take the Paraitan Rumanina, take a Paravela, mankind. Right? Even they have Velasca, right? Naturally. It is very unfortunate in this country, right? So basically, constitution is regarded as a civil religion of the country. Americans, British, Indians worship their constitution. While this fundamental case that it is against the constitution, right? They believe that protects. No one will respect our constitution. It's very unfortunate. Except Tamil and also people. Then public they don't respect. एक ऐसे कुछ चला इधर हमने मानो करने का इतना नहीं जब पूरा एक तकरीबन अपील लीड करती है और इधर रेस्पेक्ट करना है तो Tamil just believe is that the document that protect. Don't do the English and even in good people. In their not, there was not the constitution about that. They believe that protect. Why not work with constitution in the they can protect the law. So Sri Lanka has problems with our constitution protection of food. So just public believe our constitution is job to protect the food, not the system. If it is evidence came like in another system and I mean that the receiving because they have for the protection of the 19th amendment is there for the Haryana, you have to think. 19th amendment was perfectly there. And it was passed unanimously, I think. Japan, unanimously. In the Purvaya, independent commission according to this correct, 19th amendment. Right? Go to after the one maker. right? So that is our conclusion. As a graduate, you need to have a good understanding about the conclusion, right? Or again, I phone the conclusion. So that's the most important and the supreme law of the country. Right? All other laws should comply with the constitution. Constitution is ruling and the product in the back. Comply to that, criminal law that, all that, the constitution is right. So shareholders' powers, right? So they can exercise shareholders' power at shareholders' meeting or members' meeting, right? Or, as I told you before, resolutions in lieu of meeting, which is not a physical meeting, but like a virtual meeting. Right? That is also recognized by the Temperature and Section 140. So those type of resolutions that companies can pass are two types as ordinary resolution and special resolution. What is ordinary resolution? Ordinary resolution is a resolution passed by more than simple majority. 51% of the voting rights who are entitled to vote at such a meeting. This is ordinary resolution. Generally, almost all the business of the company can be done by passing ordinary resolution. That's the reason for almost all the companies to acquire more than 51% share. If they have more than 51% share, they have 51% voting rights. That is a requirement to pass the ordinary resolution. So that is the requirement to from the company. Say as an example, if you have 51% share, you can appoint Galle. You can remove Galle. Right? You can do almost all day-to-day business. So then you can control the company. That is why people try their best to acquire on that 51% share. Even if you make a contract one day, form a contract, make sure you have 51% share. Even if the other party is your wife, only give 49% share. Don't go for 50-50. Right? Take a question. 51% amount share. Right? Why is that? I'm just going 51% can take rather that's the right? I mean, the control is shareholders, somehow he done that, right? 50-50 can money. Plus now, 51% you can control. You can remove the other plan from the left. Right? So therefore, try to have a 51%. Then you can control the company and even remove the golden play. Right? So what that's known as the simple majority. Same as in the parliament. Even in the parliament, almost all the act can be passed by simple majority, including the budget. Right? Because here the husband after you give a development on the amount you have 51%, that is more than enough to our country. Right? Even you can pass budget with simple majority. So if there is a special requirement like to change the constitution, right? Like to change the European system or that's a flag, whatever. There are some changes of the constitution that you can do in the simple majority. But almost all the general business can be done, including the budget. But there are some types of requirements on the constitution, they require 2/3. Some of them require 2/3 plus referendum. Because some of the referendum if they affect the human rights, right? Then the court such amendment has to be done by 2/3 plus referendum. 2/3 Kila, Mahadana, so there are other times, right? It's a Tagala. Inside the area of that, right? So for some type of business, right? But almost all the day-to-day business can be done by passing ordinary resolutions or even the parliament by simple majority. So as it compares, almost all the day-to-day business can be done by passing ordinary resolutions. That means if we have more than 51% of voting rights. So, what type of business can be done by passing OD resolution? One of the example feedback here for the requirement of OD resolution. They don't come to your mind. Search. Search around the requirement of OD resolution. What type of business are required to pass the OD resolution? Those are the general business you all know. Yes. One example. Those are such a simple question, but you are not able to answer. Right? So I was just finished marking of the first year papers yesterday, right? So I was wondering, I have got a people question that probably get a pass following my slide. There's a one question, what is law? There were about 15 students, they have not tried that answer. That is why sometimes when there are questions, even though you know the answers, you are not comfortable to write something. So I didn't expect much. If you have those are some rules and regulations, I would give them some marks. But even that was not written. If again, then you all know what are the requirements of the OD resolution, but you don't have answer. Yes. Not in the business. Yes, to appoint a director, to reappoint a director, to remove a director, that can be done by passing OD resolution. What else? To pay dividends or to make a distribution, right? To make a dividends or to make a distribution, they also have to be approved by a OD resolution of shareholders. Yes. Yes, to appoint auditor can also be done by passing OD resolution. But yes. To approve annual accounts can be done by OD resolution. Okay. To appoint auditors can also be done by. Yes. Okay. To change the conference register at the change the conference register at the definite. To approve a director's remuneration, right? So, directors are entitled, they are not entitled as a right, but they only entitled if it is approved by the shareholders resolution. If the shareholders do not approve, then they are not entitled as a right. So those are the business, right? Almost all those business can be done by passing OD resolution. But more of the time, very OD resolution. There are some type of business. There are some type of business where they materially affect the stakeholders. If some business materially affect the shareholders or the stakeholders, then it is not nice to change by simple majority, whereas some companies, 51% belong to one person or one group. Therefore, there are some requirements under the Companies Act. There are some selected business as they can materially affect the business of the or nature of business of the company. They cannot be done by passing only resolutions, and they must be approved by more than 75% of approval of the shareholder. Right? So, in company, it is known as the special resolution. Therefore, those type of business, they are mentioned in section 92, require the approval of special resolution. Right? Therefore, the businesses which are set out by section 92 can only be done by passing special resolution because they can materially affect the business affairs of the company. Okay. Look at section 92. What type of business are there? They can be done by simple majority. No board can do it. Take a board there not bad. Simple majority not bad. 75% shareholders must help before that. What are they? The alter the articles of association of the company. That is fair enough. That can materially affect the business. Therefore, simple majority cannot do it. For that, 75% of shareholders must agree. Okay. What else? To approve a major transaction. So, what is a major transaction? Basically, it is a transaction which has the effect of more than half of the assets of the company. So that also can materially affect the business. Therefore, the board cannot do it. The simple majority cannot do it. For that, the clear majority, 75% of shareholders must sign. What else? Amalgamation. To amalgamate companies, there are some issues with the companies. Right? Then they have an option to terminate the affairs of the company, obviously winding up, right? But without going for winding up, there are some non-terminal affairs of ending the company affairs, right? They include those amalgamation, mergers, acquisition, and all. So therefore, that is also an important decision of the company, right? Then to go for amalgamation, that also can be done by the board or by shareholders. That also has to be approved by the 75% of shareholders. But remember, only one type of amalgamation, right? There are two types of amalgamation. What are they? There are two types of amalgamation: short form amalgamation, long form amalgamation. What is a short form amalgamation? Short form, that is the political. No. Short form amalgamation means the amalgamation of the parent company and subsidiary or two subsidiaries, right? When company amalgamate with their own company, it is known as the short form amalgamation, right? If a holding company amalgamated with the subsidiary company, it is known as the vertical amalgamation, vertical short form amalgamation. When two subsidiaries amalgamate together, it is known as the horizontal short form amalgamation. For that, you don't need the approval of the shareholder. That can be done by approval of the board. Right? It is their own business. Right? So, short form amalgamation can be done by the board of directors of two companies. But long form amalgamation, that's the important thing. Long form amalgamation is the amalgamation of two independent companies. Right? When two independent companies amalgamate together, then it has to be approved by more than 75% of shareholders. Therefore, the amalgamation means by long form amalgamation. To amalgamate two independent companies require more than 75% of shareholders consent. Right? That's what they that can be done by them. Right? Okay, what else? To reduce the stated capital. So stated capital, so it is a fundamental concept of company law that the capital should be properly maintained. Right? So you can't, or the board or company cannot pay with the stated capital of the company. Therefore, capital should be properly maintained. So if there's anything which affect the or reduce the stated capital, the board can't do it, majority can't do it. It also has to be approved by the 75% of shareholders. The company has to pass a special resolution. What else? To wind up the company voluntary under section 319, also required to pass a special resolution. So the 319 means if the articles already provide that company can voluntarily wind up after achieving some event or after 5 years time, then there's no requirement of special resolution because articles already provide. Then the simple management can do it. But if there's no such requirement, no such process in the article, then it has to be approved by more than 75% of shareholders. Okay. What else? Sorry, to change the nature of business. Nature of the name. To change the name of the company. Yes. To change company name is also important thing. That's also affected this. Right? Therefore, to change the company name, that also has to be approved by more than 75% of the shareholders. And lastly, to change the status of the company. Right? Therefore, to change the nature of business, to change the object of the company, that also has to be approved by more than 75% of shareholders. You can carefully think of those requirements. All of them materially affect the business affairs. Therefore, that type of thing can be done by passing voting resolution. They have to be approved by more than 75% of shareholders. Okay. So that's a requirement of special resolution. Except what is mentioned in section 92, all other business can be done by passing voting resolution. Is it clear? Requirement of special resolution under section 92. Requirement of voting resolution. Right? There's not right. Right. So now what is a special resolution? Special resolution the next one. The resolution passed more than 75% of shareholders who are entitled to vote at the meeting. Not perfect. So this is only resolution. Resolution passed by more than 75% of voting rights with 15 days prior notice. With 15 days prior notice. Otherwise, even though it is passed by 100% voting rights, if there were no such notice, it is not a special resolution. 100% unanimously passed. If there is no 15 days prior notice, it is not a special resolution. Special resolution is passed may meet with the pass run here, if you want to change that time period, it has to be approved by 100% share. They got so therefore, special resolution is a resolution passed by more than 75% of voting rights who are entitled to vote at such a meeting with 15 days prior notice. That is the special resolution. Right. Let's celebrate because my car is also in the garage. They want to take my car. I don't know whether it's available. We have a break and Online people have a break. Have a glass of wine or coffee. I'll be back.
Wow.
they have some unfettered rights like right to watch, right to dividend, and right to surplus assets. Apart from that, their rights obligations are decided by the Companies Act, Articles of Association, and also by the Common Law. So generally, it is well known established rule that shareholders' liability is limited, but it is only true for the limited company. In widely, shareholders' liability is decided according to the type of company, because liability of unlimited company, members of unlimited company is really different from the members of limited company. Members of limited companies liability is different from the members of guaranteed association not for profit. Therefore, they are liability decided by the type of company and also by the Companies Act and Articles of Association, and also by the agreement they have with the company, and their delictual wrong also may affect their liability. And then we discuss how do they exercise their powers. So shareholders exercise their powers at meetings passing resolution. So we also recognize there are mainly two types of resolutions as ordinary resolution and special resolution. Ordinary resolution is a resolution passed by more than 51% of voting rights, and the special resolution is a resolution passed more than 75% of voting rights to an entire vote at such a meeting, plus with 15 days prior notice. So we also discussed the requirement of special resolution and what type of business can be done at passing ordinary resolution. So that's what we have discussed so far. Now we will discuss the other type of resolution, written resolution or resolution in lieu of meeting, recognized by Section 144. It's not there, but anyway, I will explain it right now. So, you have a textbook, right? Section 144, recognize resolutions in lieu of meeting. නීතිමත් වෙන්නට යෝජනා සම්මතයක් කිරීමට යටි resolution in lieu of meeting. Basically, you know the result of a physical meeting. Probably you have a meeting in your organization, in your business, and in any other places you have, probably you have participated and members of such meeting. In Srilanka, you know the result of effect of meeting, right? Meeting, eating, sleeping, talking, nothing. Right? They keep the time in country, Srilanka. Right? So, but it's not easy to have a meeting, especially company meetings, right? You have to book a place. Before meeting, you have to send a note, right? Then you have to book a place. Then you have to arrange transport and all. Maybe accommodation for the director, right? Maybe some refreshment. If you cannot conclude the that meeting within the day, you have to book again for another day. Likewise, it's not an easy task, right? Therefore, these people who draft the Companies Act recognizes that company meetings can be done even without any physical attendance. Therefore, company meetings anyway can be done now through online using the internet conference technology. Even apart from that, under this section, it recognizes that there's another way to pass resolution without having any physical meeting. So you know how long it takes to have a company meeting and pass a resolution. This is the only resolution. You have to inform the members before 5 days, 10 days, and so on, so according to the type of company. This is a special resolution. You have to inform it within 15 days prior to the meeting. Right? So sometimes business can be done in that way. Therefore, why respecting those traditional law, it recognized that you can have a physical meeting and pass resolutions. Is also recognized a new way of passing resolutions by way of written resolution by section 144. In fact, this is the result of one Canadian case. In that case, there was a company at that time not to have a first annual general meeting, which was recognized as a statutory meeting at that time, was a reason to wind up the company. There was one company, they have not held that first AGM. However, with the consent of all the shareholders, they have signed it up. When there's a litigation, they presented to the court that all the shareholders, 100% shareholders have agreed and passed that resolution in place. So court recognized that it is equivalent to a resolution passed at a meeting. But they said it is not a procedure. It is only limited to that case. However, the same situation is recognized by the section 144, where without a physical meeting, now you can pass the resolution. Right? The only requirement is here that, yes, if you can send the resolution, copy of the resolution to more than 85% of shareholders. It is not 51, it is not 75. It has to be signed by more than 85% of shareholders. And then, if they can get their approval with their signatures, then it is equal to a resolution passed at meeting. It may be either ordinary resolution or special resolution. If it says ordinary resolution, then it's ordinary resolution. If it says special resolution, then it becomes a special resolution. So therefore, all those requirements of physical meeting to pass a resolution now can be done within half an hour. If you can send the email to all the shareholders, this is such a simple thing today. If you can get it back, then it is equal to a resolution passed at a meeting. So that is some of the good trend, good law for the busy modern business thing. All those things can be done within half an hour. Very good for the private companies. There are few shareholders, maybe 2-3 shareholders. So, however, there are some requirements, so accordingly, it has to be signed by more than 85% shareholders, and the person who do not sign it, maximum 15%. So the company has to inform them, or provide them the copy of the resolution within 5 working days. Okay. Those people who did not sign the resolution are entitled to have a copy of the resolution within 5 working days. And also, if the government is a shareholder, if the treasury, the secretary to the treasury is a shareholder, then without his or her written consent, written resolution can be passed. Subject to that, now companies can pass a resolution without having any physical meeting. Right? So therefore, they are known as resolution in lieu of meeting or written resolution. Even when you file the annual return, now there's a separate question, the last annual return date or date of resolution in lieu of meeting. Right? Therefore, now companies are no longer required to have a physical meeting. Right? They can pass resolution without meeting even for years. So companies can't even run without having physical meeting even 10-15 years. They can pass the resolution. So probably good options, right? Especially country like the Corona, whatever, very good option. So that passed in 2007 and drafted in 1995. They were not thought of the Corona and all, right? Lockdown and all, but it's still good option, right? So very benefit to the modern business. Right. So that's a resolution in lieu of meeting. Right? So it's not only resolution is required to pass with more than 51% of voting rights or simple majority. Special resolution required to pass more than 75%. Resolution in lieu of meeting required to pass more than 85% of vote. They have decided it's a written resolution. So those are the type of resolutions, and that is how shareholders exercise their power. But that we have already discussed that every company is required to maintain the share register. That record the shares issued by the company. Right? Some should not be entered in the share register. So share register must be kept at the registered office. They are requirement. So companies who has more than 50 shareholders have also required to maintain the index register, which is also a share register according to the name in the alphabetical order. So the rights and obligation of shareholders is based on the term of issue, right? Whenever there's a share issue, there's a terms of issue, right? So that becomes basically it is in the prospectus. It is a PLC, right? So those prospectus or terms of issue become a part of articles. Once they issue, they become a part of articles. Then they become a contract. And then they become part of articles. Article is a contract, right? So in law, there's a presumption. In law, there's a presumption that all the shareholders have equal rights. Presumption means it's a rebuttable presumption. But the presumption is that all the shareholders are equal. Bank is known as paripastu Latin term. But paripastu is a Latin term that means all shareholders are equal. However, it is subject to the terms of issue. When share issued, if there is a priority given for some type of shareholders, as an example, if some priorities are given to the preferential shareholders, then they can prove that they have a priority. But subject to the articles and terms of issue, generally shareholders are ranked equal, right? That is a presumption. That presumption can be rebutted by version of the company's article, because it is permitted by company's articles that companies can issue different type of share. Then they have different type of priority. Right? If there are no such priorities, then the presumption in law is that all shareholders are equal, all shares rank equal, especially in the wine. Right? So the presumption contract law. There's a presumption in contract law that in domestic agreement there's no legal intention. There's no legal intention in domestic agreement. Therefore, court will not enforce. In commercial agreement, there's a presumption there is a legal intention. Therefore, court will enforce. However, those presumptions are also rebuttable presumptions. With the evidence, you can prove that there is a intention given in the contract between husband and wife. Something like marriage versus marriage. Do you remember? Maybe don't know that chapter. Contract law is part of contract. Domestic contract is a main part of contract. The presumption is domestic contract. Presumption is there's no legal intention. That is why court will not enforce it. But this is a rebuttable presumption. Maybe they will make the people. There was a piece of document. They were not living together. So court decided they entered into the agreement with the intention. Lower all the presumptions here only. Well, then they did not say the presumption. Yes. So man and woman live longer period, probably more than 7 years. There's a presumption that you are husband and wife. Don't think that will be the certificate for the people. Okay. Marriage is not required to be registered to be a husband and wife. Right? Marriage. They do long at the period. Probably love someone again out of I'm managing. It's just not that. So there's a presumption that you have to that. Yeah, property not I can hear much. Lower can manage that to be registered. So customer managers are accepted. Right? You know, right? Oh, you know, apply for the personal resource, right? If a person is not heard longer period, again more than 7 years, what's the presumption? Person is dead. This when you get the death certificate. That's a presumption. That is also a rebuttable presumption. In tsunami case, it was settled 2 years. Tsunami case, it was settled 2 years under death certificate ratio. Somehow, cancer. So, a presumption over it. So, it's one of the presumption over it. Criminal law, lower field. If a boy is under 13 years, then they can do they cannot do a like. Although the student are the collector, they have to bear in the person. They can rebuttable they can do. They can permanent. They can depend on the medical evidence. Medical evidence, sexual feelings in the health of we must believe, right? Someone has a medical evidence in a bad. Somehow that will give a money to name and somehow teachers are work for someone can. Someone teachers are one room for you to take that. So do that whom will you do not allow system and a months of teachers over the other time. Here, parents are meet how to the high for him. Then it's nanny. If you study, you make it take not work of that. It's a presumption that they cannot make do it. So that's what for you to get to the right. Very good assumption. I mean, if a person is less than 8 years of age, there's presumption that they can do a time. Also, after argument, 8 to 14, the judge has a discussion. 8 to 14, judge to put on the self and the intention of the all the presumption. Lower presumption, right? So, compare over this function we have summarized. All shares are equal. They rank equal. But it is a rebuttable presumption according to the term of issue and according to the articles of association. Some shares may get priority. If there's no such priorities within the articles or term of issue, at the winding up, all shareholders are ranked equal. Interest group, I will explain separately. So if those shareholder rights are violated or infringed, what they can do? In fact, that is the only thing according to me that they can do as a shareholder, right? There are some certain recognized rights under the Companies Act. If they are infringed or violated, then those shareholders can file a case against the company or directors or those respected parties to protect their rights. Those remedies were a personal action against the company when their individual rights is infringed. There are some personal rights they can file against the company, or maybe some class or group rights, where some group may be 5% of shareholders or 10% of shareholders, or maybe ordinary shareholders or preference shareholders. As a group, they can find a case to protect their rights. So now we will discuss what are those rights available under the Companies Act for the shareholders and how they can enforce those rights against the company. fact, these are the right of shareholders under the company. Right. So basically, companies are run by who? Companies are run by the majority shareholders. That means the shareholders who together have not less than 51% shares or 51% voting rights. The reason we already know, then they can control the company by passing resolutions. The best example is that if you have more than 51% shares, you can appoint directors, you can remove directors, you can approve dividends for distribution. Right? So that is how they control the company. So this in law or even the political science known as the majority rule or democracy. Right? So that is how companies are also ruled and run. So this tool is accepted by a classic case known as Post versus Hart. Right? Post versus Hart. The classic case is company law. In that case, there was two directors of the company where they have bought a land purported on behalf of the company and resold it to the company for double. Okay. So directors written that they have bought the land for 20,000 for 50,000 pounds and resold it to the company for 100,000, making 100% profit for themselves. So this transaction clearly made good profit for the directors and huge loss to the company. However, thereafter, there was a shareholders meeting. At meeting, probably those directors are also shareholders. The shareholders passed a resolution that even though this transaction made some loss to the company hereby resolved that the company will not take any action against those defaulted. They pass a resolution. Those probably shareholders directors are there. It's not clear by the case, right? Most probably those directors are also at the shareholders meeting. So they have passed a resolution. However, 3 months later, 2 shareholders filed a case against those 2 directors. So that is the case. The question was whether those directors are liable to pay that amount back to the company. So if they are any legal, what do you think? If you are the judge of this case, what is your judgment? Whether directors are liable for making loss to the company? So they have done. They have. Okay. They have. They're liable to pay loss to the company. Right. So probably you all believe that the directors are default and they are liable to pay compensation to the company for the loss. Right. But English judges thought different. But anyway, this is a House of Lords judgment, because in the trial court they have decided like you said. Right. You can appeal to the appeal to trial court different judgment they have to is the trial court ticket, appeal court ticket here, every liable case. But I made a House of Lords judge. When House of Lords for the Supreme Court decides something, it is almost like a law, isn't it? So Parliament can also pass laws. The judges also can make. When High Court judges decide something, it becomes a proceeding. So then, in a civil case, lower courts have to pass. Right? Come on. Judicial proceedings के लिए क्या है? एक पारा जज में क्या है? हम एक वैल्यू ना दिखे तो क्या? Right? because it's the accepted principle in common law countries known as the judicial proceeding. If the Supreme Court decides something, all the inferior courts have to follow that judgment in civil. If Court of Appeal decides something, then all the lower court, except the Supreme Court, has to follow that judgment in civil. ඒක තමයි අපි කියන්නේ judicial proceeding. Istare diseases කියලා කියනවා Latin word. Settled decision කියලා. ඒක අපේ රටවල follow කරනවා. American state එක ගණන් ගන්නවා. Commonwealth countries වල අපි ඒක follow කරනවා. It is still good to maintain the certainty of the law. ඒක නඩුවේ ඒක තීන්දුව people won't respect it. Inside all really help to maintain the certainty of the law. American side of the government, that limit the freedom of justice. That limit the freedom of justice. They should have freedom to decide cases according to their circumstances, and also they believe that no two cases are similar. They will hit the next case. They have some on it. They can tell them. This I go to follow them, but we follow the English traditions. We follow. These are some of our career. Then we still are. පාති මාළු කරද්දාස ස්වාමීන් කියනවා නෑ ඒ ෆ්‍රීඩම් එක තියෙනවා කියලා නේ ඊට පස්සේ ආයෙකින් පස්සම ආයෙ නඩුවක් දානවා ආයෙ කියනවා ඉස්සලා එකාට පුළුවන් මේ හින්දා ඒ ෆ්‍රීඩම් එක කියලා යූ කැප් කියලා නේ ඊට පස්සේ දැන් පාති මාළු ගලාම නඩුවක්වත් ගන්න because it is very safe that they have such a freedom නේ හැබැයි මේ සිස්ටම් එකේ තියෙන්න බෑ මං හිතන්නේ ඒක මම හිතන්නේ වැරදි දෙයක් ඒ වැරදි උනත් දුන්නට පස්සේ දිගටම යනවා නේ හරියට Muslim case එකක් තිබුණේ මොකද මුස්ලිම් ප්‍රවර්තන වෙන්නේ Muslim Mekere, he was married and without having divorce, he married for a second. They were not Muslim in fact, he was a Christian by birth. He was Christian by birth. Without having a valid divorce, he married the second. Then the first wife filed a case. Lanka became a criminal offense. To have a second wife, to have two wives is a criminal offense in Sri Lanka. Unless you are a Muslim. Muslim might take it out. You know, Muslim make a criminal offense. Muslim might take a religion. ඊට පස්සේ first time අනුවදාන ලංකාවේ ඉන්න රැලි කරනවා at that time our highest court was the Privy Council which is situated in India. Until 1972 our highest court was the Privy Council. India did not find that Privy Council decided කරනවා they took the advice of the Muslim lawyers campaign. Right? They decided that the argument was at the time of his second marriage he was a Muslim. That was his argument. Right? Then Privy Council had the question whether he was a Muslim or not. That was the question. They were in opinion that if he was Muslim, then there's nothing wrong with the economic Sri Lanka. Lanka Muslim happening. You can be a Muslim by birth or by converting to your religion because it is also recognized by our constitution that you can convert to your religion at any time. If you don't have protected. ඊට පස්සේ බැලුවා කොහොමද මිනිහ මුස්ලිම් කියලා හොයන්නේ කොහොමද බලන්නේ මුස්ලිම් නැද්ද කියලා ඒකෝදී එක්ස්පර්ට් එකක් තමයි කියන්නේ you believe in only one God ඒක දේවාලයේ කියන්නේ Muslims only believe in one God in all other religions they believe more than one if you only believe in Allah the judges was the opinion that's the minimum requirement to be a Muslim so Reed said I only believe in Allah. The judges won't accept what you say. So it has to be like proved by the independent evidence. But it was very lucky. There were some priests and some other people. They gave evidence that he was a Muslim. He comes to the mosque every Friday and so on. The court satisfied that he was a Muslim. Then the court decided there's nothing wrong in proceeding. ඊට පස්සේ ලංකාවේ අවුරුදු 35ක් තිස්සේ මිනිස්සු මේ වැඩේ. right? බඳිනවා මුස්ලිම්. බඳිනවා වුණාම Muslim. It was a 1996 our case, Natal versus Christopher case. Christopher versus Natalia. Taking it to put the American because previous one was decided by three guys. Therefore, they appointed 5 years, then they get give us their charge. Taking back his against Sri Lanka, they will do a real case was a mistake. Real case was a mistake, and they decided that if you want to have a second wife in Sri Lanka, your first marriage must be under. Then only you can have a second wife there. It's not how many people that in partner with you. Like it will answer that thing, right? If you want a second wife in Sri Lanka, your first wife can be after Muslim. However, some Muslim lawyers feel like this case. Muslim lawyers are getting a real case like our holiday. But I hope it's a good law in Sri Lanka. I didn't need to it over there. Then for a while, not Muslim, right? Like the holiday, almost the part of Balna Gana, but I have to do it. You part of the personal picture. The part of Colombo, you know, I think I have to let it will have to win the tag at the for their attitude. Right? The main case anything just the courts decided different. The attitude was completely opposite of party. In this case, court even didn't take the case to the end. They set aside the case. In their opinion, there's no even case to him. Right? In this case, right? But they have to give reasons for their decision. Judges are always about to give ground for their judgment. So, some of the reasons that they have mentioned, some main reasons. One thing is that the separateness that you can join, right? They were in the opinion that if there is a loss, it happened to the couple, not to the individual. Therefore, the proper state, the proper person to file a case is the couple, not the individual. In this case, the case was filed by individuals, not part of the comparison. But courts also the opinion that if there's a loss, it happened to the company, then if something happened to the company, who is the proper people to file a case? Company. The company should file. They will complain on them, but they have filed a case under their personality. Right? Therefore, court decided you are not the proper case. After that, idea is different. The insurance not even that time. But again, I'll look at the insurance side and I'll look at the protection line and the bed. They are must be one reason. You should not interest the reason. If company lost happened to the company should file a case. The proper case is the company itself, not individual. Because loss happened to the company. Another reason was to respect the majority decision. Because majority shareholders have already passed a resolution. What's their resolution? Not to file a case against those before the death. When majority shareholders have decided something, the court will not interfere this unless there is a clear injustice happen. Loss and profit is a part of business. So court will not interfere the business action. If court going to interfere, this is wrong, then you can't fund the business because you have a duty to respect the majority. Therefore, as majority has decided not to sue against those before directors, court decided the court is bound to respect the majority. That was another reason to set aside the case. Another ground was to stop the multiple case. In companies, you know, there are thousands of shareholders. If all shareholders going to file a case that I lost because of this stock and so from the court cannot do anything else in those cases. Right? Therefore, to stop the multiple case. That is why case has to be filed under the companies. Right? Those are the main reasons mentioned by the court to set aside this case. Okay. To respect the majority wish, to stop the multiple cases and what is known as the proper pay. So after this case, business people were proved. Anyway, business were run by the majority shareholder. After this case, it was like the court has also given us license that we can do whatever we want. Right? Therefore, they started to ignore the minor shareholder. That made huge problem in the business. Because business somehow shareholders are coming that money. So that made huge problem for the business and smooth running of the business. This is common even for the country. Sri Lanka, I hope, is the best example. They are in the war more than 35 years. Right? So it is true that we have to respect the majority. So you have to respect the majority signalist. At the same time, you have to protect the minority Tamil Muslim members. Then only you can see a peaceful country. Right? A massive business. You have to respect the majority. At the same time, you have to protect the minority shareholder. Otherwise, you never will see a smooth running business. So this is recognized by the English Parliament as well as English judge. Therefore, in later cases, when there are such cases, English court, right, gave some compensation or remedies for those minor shareholders. They were developed as exception to the first causes arbitral case or as minority protection. And also, English Parliament made some amendment to the Companies Act to protect the minor shareholders. They were developed as minority protection rights or minority shareholders. Okay. So, following those, the merge of the court decisions and the English amendment, the Sri Lankan Act 2007 also provides a number of salutary provisions for the protection of the shareholder. So we discussed what are those provisions available in the Companies Act of 2007 for the protection of the minor shareholder. So still law is majority rule. Majority can run the business. However, at the same time, it is well recognized today that companies have a responsibility to protect the minor shareholders. Because in many companies, it is obvious that major shareholders are either one or two groups, maybe one person or family of group. 49% shareholders are thousands of people. Therefore, you have to protect them more. Right? So we'll see what are the accepted rights in Sri Lanka, right? Companies right run by majority shareholders. Probably board of directors comes from the majority shareholders. If not, definitely board has some close relationship between them and the majority shareholders. Right? Whenever there's a meeting or whatever, they are called and called by the board of directors. Right? When there's a proxy or whatever, they are also checked by the board of directors. Right? Therefore, they clearly control the company. Majority shareholders. Therefore, it is unlikely for the minor shareholders to file a case and sanction. So that is why they are recognized. You recognize those rights from my right. So first, under section 224 and 225, oppression and mismanagement. Section 224 and 225. Oppression and mismanagement. In Sinhala, we call them oppression, Pida Karin Tesaha, Ayata Kalmanaka. I'll explain both sections in the same time now, right? Same procedure, right? If a company the company runs its affairs in an oppressive manner to the minor shareholder. Okay. Then under this section, those minor shareholders, if they together have more than 5% of voting rights or 5% of shareholders, then they can file a case under this section, saying that the majority shareholders act is an oppressive act. Okay. So, in the same manner, under section 225, if they can prove that the management mismanaged the affairs of the company, if there's a mismanagement of the affairs of the company, again, it's those minor shareholders who were affected. If they have more than 5% shareholders, shareholding rights, voting rights, or 5% shares, then again together they can file a case. So here you can see, if they have 5% share, they can file a case against the company where they may have 95% of share. Right? So according to the majority rule, if you have 51% of shares, you can control the company. But if there's an oppressive act by the company or majority shareholder, or if there's a mismanagement of the affairs of the company, then that majority rule, there are exceptions. There are rights for the minor shareholders, they can file a case under these two sections. So anyway, unfortunately, it's not unfortunately, I think that is the argument in this case. The law does not clearly define what is oppression, what is mismanagement. Right? So according to each case, the judges to be decided whether it is oppressive act or mismanagement. Right? Recently, about 4 or 5 years ago, there was one subsidiary of John Keats Company, where was a subsidiary of John Keats Company. There are only 3 shareholders. One shareholder had 95% share. Another shareholder 3% share. Another shareholder 2% share. Right? For 15 years, that company has not sent annual return to that minor shareholder, to shareholder. Only the shareholder who has 95% share, probably John Keats Company, right? So everything is done by them. The other 2 shareholders who have 5%, 2%, not sent any annual return for 15 years. They have not given any dividend. So those 2 people filed it. They filed a case under the oppressive. So it was under this act. So law recognized that it is an oppressive act. So the court, commercial court ordered the John Keats Company to pay compensation and to pay dividends for over the 15 years. Right? Therefore, in such a case, you can file a case. Right? This is an oppressive act. Right? Even under dismanagement, even though it is not defined by the act, so there are a number of cases. If the board members are appointed without proper leave, right? Sometimes the directors themselves appoint leave. They can appoint if they have given powers, if the article provides. Sometimes, even though there are no such persons in the article, the board appoints other directors. So it is a mismanagement. It's the expense of the board members, right? So those can be considered as a mismanagement. So if they enter into the contract or made a transaction without following a proper procedure, it is a mismanagement, right? In such a case, if you have 5% share or 5% voting rights, then you can file a case against the company under these 2 sections. At the very beginning of oppressive and mismanagement law, the court's attitude was to wind up the company. What do you think about that? At the very beginning of this law, oppressive and mismanagement were recognized by the English court, the first remedy was to wind up the company. But today, in many cases, court will not take step. Still, that option is there. But winding up company does not serve to any community. Right? Therefore, this is well recognized by the Commercial High Court. Therefore, now there are some other remedies instead of winding up of the company. Now, court will not take a step to wind up the company just because of there's a oppressive act of mismanagement of the affair. Right? There's an appointment of the director for the board without following the proper procedure, which is not a reason to wind up the company. Right? So you can remedy that shareholders who were affected. Right? Even in such a case, if they were not paying dividends or whatever for years, so you can order the company to pay them maybe with some interest or whatever. So that is fair enough. So that type of remedies are followed today more than winding up of the company. But traditionally, whenever there's oppressive act or mismanagement of the affairs of the company, the shareholders file a case and the court took the step to wind up the company. Now, more remedies are provided for those accused parties, and the court will not take a step to wind up the company. Right? However, under these questions, let's see who filed a case. A shareholder or shareholder during the 6 months prior to the making of the application constituted not less than 5% of the total number of shareholders, or held shares which together carried not less than 5% of the voting rights at the general meeting of the company, then they are entitled to file a case. It may be either joint shareholders or even the one shareholders, they have 5% rights. Right? So they can file a case against the company. So it's a good option for the minor shareholder. Minor shareholder. Right. Procedures, you don't need to follow them, right? So, I also have a case, this place, my company has made us a case here, private limited. If it's a operational mismanagement, but not they get make a shareholder in nothing, so he says that he has given his shares as a trust, but I think commonly, common trust a cancer class is that again, commonly, a very beautiful parent, the private company, but for 250 million investment. The other shareholder who is in UK have filed a case under operational mismanagement. 50% of our shares to nearby. 50% people get 50%, 51%. Is about 50141. I can take care of that. So I have. Because I have 51%. But director will one share didn't feel. They are directly got used to and we got 400 for my company. There was a trust anyway. After a trust, I leader will have data. I cancel the the court will decide. There are 3 cases. One is before the district court or the trust case. Trust case in district court. So the company matter, you can't go to the district court, it's the Commercial High Court. And oppression and mismanagement, there's another case before the Commercial High Court. There's another criminal case before the next. Okay, but another case, all signatures document here. Criminal case magistrate court company case again oppression mismanagement under the Commercial High Court. Trust case available district court. Court because to the checks were not case, criminal case, another case. So, it's a different than the mismanagement oppression, right? Maybe the area of the right. So, restraining orders. Well, at PMR, I think we have discussed last week as well. Right? 2 weeks, then 1 week. So rest training orders that are clean out, right? So under this section 224, let's next 233, 230. Rest training order, right? So you can see if the company's conduct would contravene the Companies Act or the Articles of Association. Right? The company's conduct contravening the Companies Act or the Articles of Association, then a company or director or shareholder can file a case against the company. Here you can see even one member can file maybe against the thousands of shareholders. Right? So if a Companies Act or Articles of Association is violated by the company or board of directors, then the aggrieved part can file it. Here, what is important is even a shareholder of the company can file it. Director can come, shareholder can come. So 5% not in line. So very good salutary position for the minor shareholder. Right? So, but to file a case, there must be a breach of Companies Act or Articles of Association. Then they can file it. So then court can make an order restraining that term. We when they can depart like a panda, you again then. Section 233. If the company has an object, where is it? If the company has object, where is it? It is in the Articles of Association. So if the company or directors, now let's say company is incorporated to sell chocolate. That's the object of the company to sell chocolate. Now this company sells shoes. What is it then? It is a breach of Companies Act. Then the shareholder can find a case under this section. Therefore, if company do business which is not provided by the object clause or articles, then a shareholder can find a case under this section. So, however, just again have a look section 233 4. Monkey part of 233 4. But the 68.
An order may not be made under this section.
Under this section, court cannot make order if those contracts are already been completed. So why there is such a look? To protect the third parties who enter the contract with the company in good faith. So therefore, that section, yes, have provide some remedies for the shareholders while they protecting the third parties to the next. Because contract is good. Court cannot order in the third party if the contract is already been completed. But court also protect the right of the shareholders. They can file a case. Once they notice that they going to breach or break the company's articles of object clause, like as a shareholders, there are some meetings or whatever, then those messages come to them. Then before they engage with the third parties, they can file a case. At that point, court can order against the company to restrain entering into new business. But however, if it has been already been done, then court cannot order against the company. So this is also good provision because even one shareholder can file it. So this is the injunction. So to restrain wrongful act, or illegal act, or which is not provided by the object or so articles, which are threatened or imminent but have not yet been commenced. If it is commenced or completed, this court cannot make any order. It's another salutary provision under the Companies Act, derivative action. Derivative action, we put under the here. Derivative action means when a wrongful act is done by the majority. When the wrongful or fraudulent action is done by the majority, it is obvious they never will file a case. Right? Then case to be filed by the minor shareholder. If majority rule prevails, they never will success. Right? That is why under this section, derivative action is recognized. Then again, minor shareholders can file a case against the majority under this section. However, this is not a right because this is also given even for the one shareholder, right? Some context there may be thousands shareholders, right? But if one shareholder can stop their business, that is also not fair, right? Therefore, they can first get the grant from the court, right? They can get the leave from the court to start the process. But if there's a proper case, then court definitely will grant license to go ahead. Okay. So we will start with one of the very popular case in Sri Lanka under this law, right? So known as Amalasekar versus Mitsui and Company Limited and other, commonly known as Hilton case, which is about so-called Hilton Hotel situated at heart of Colombo, which is a case Sri Lanka. It's Hilton Hotel, right? There are a number of cases against those so-called hotels. If you know, you never will get your wedding at their Hilton, right? From the very beginning until today, right? This is all now. Oh, on side. You could not say that at the Hilton. Under the one Mokika done, Lanka, the Kapas Mokika done, they are Lanka, we can do not that. Either like business taker, the Mangata like a Kia Pat express can we can done the Kia. Eight Mokika gas, the Mangata Antiburan may up to night and a month like I give us that two got like eight gun at the very. Right better, we can done it. We can do that. Eight Taran live. Capacity live with this and pick up a because we are that. Then this one, there is also this is a pattern. Business that can get some other people, company, private company. These are the Korea. Galakada didn't effective. Mukikal political. These are that they are not here. What you have to be not here. Then they go on to do another. Constructive was even common, it is a hate on the table. If you have a business of stylish stage that outer room, Muslim leading that outer room, then Tavaki color moves nothing. Put them for the same answer the subtract one of the Talam. Right? They used to come there now. Yamu Navila, they are the Filipino, they are very much right? In the Ganta, the Gana, and that means we had over a number of septic take care of the other one. We were getting low in the thing up to not take a monkey, right? There are terms to do. Even the time with the suicide make a Hilton theatre, Pataka da in the man. Right? How to Pahala is and return on man, we are a deal is correct. A list that compare because deal is correct. We pass it. rent එක කියලා නැහැ, lease එක කියලා නැහැ, අවුරුදු ගාණක් ආන්දුව. right. දැන් නම් sale කරන දාන්න විකල් නැද්ද කියලා මම නම් දැන් කොට අපර වාසිකා පාඩේ මොකදලා දුන්නා. මොකද ඒක ප්‍රාණවල කවුන්ට් ගන්න එකේ numbers වල. ඒ liabilities එකලා ගන්න බෑ. බිලියන ගණන් නැහැ. So this is the case about so-called Hilton Hotel, which is situated in heart of town. Basically, Hilton hotels are run by the Hilton USA, but in Sri Lankan Hilton Hotel, the major shareholders were Mitsui Corporation. They had 35% of share in Hilton Hotel. It came to Sri Lanka in 1979, just after JR opened economy in 1977. So Hilton came into Sri Lanka in 1979. From that point, they had the company here. At that time, the name was not Hilton. The name was Colombo Hotel Development, whatever. Later, they changed their name 2 times. Asian Hotels Corporation Limited, one time they changed, and next they changed Hilton or whatever, right? So they changed their name 2 or 3 times. It started in 1979. Major shareholders were Mitsui Corporation in Japan, having 35% shares. They were also main architects, main suppliers, and main contractors. Financial Amarasekar was a shareholder. He had 10,000 shares. In Hilton project, it is 0.1 shares. Sri Lankan government was also a shareholder system. So, in 1979, they started their business. In 1984, there was a fire at Hilton site. The hotel was declared open in 1987. Before opening in 1987, there was a meeting in 1986. That was the last meeting before opening. At that meeting, there was a puzzle. The puzzle was, according to the calculation, the Hilton project never ever will reach its projected profit, even if all the rooms were occupied. So that is a puzzle, right? All the rooms occupied here in Alva, they never will reach its projected profit. No, I know it. With the blue of it. Room become occupied here, then projected profit gallery projected. Lanka gallery Japan was Lanka after that. Someone in Japan gallery different country has never been anybody. Must be advantage. I was lucky to be you. Europe आता लगे रीला चला जापान गया ना भाई I feel like Japan. අපේ රටවල දිනුනොත් එන්නේ කියලා මට වෙලාව ගන්නවා. ඒෂියන් බෑක්ග්‍රවුන්ඩ් එකක් එක්ක බලන්නේ. අර වගේම නෙවෙයි වෙනස්. සමහර දේවල් දැන් වල යුරෝප් වල දැක්කම too much කියලා හිතනවා. සෙක්ෂුවල් දේවල්. සමහර දේවල් too much. ඒවා සමහර ප්‍රොමෝට් කරලා තමයි දැන් ඒ just අර මේවා ප්‍රොමෝට් කරන දැන් ජපානයේ ඒවා illegal නැහැ මම දන්නේ නැහැ. නමුත් ඒවා ප්‍රොමෝට් කරන්නේ. අර ඒෂියන් කල්චර් එකත් එක්ක තමයි වගේ. ඒගොල්ලෝ ඒවා හරි ලස්සනට මැනේජ් කරලා ඉස්සර ජපාන. ඒක තමයි මම හිතන්නේ ඒෂියන් කල්චර්. ඒවා ප්‍රොමෝට් කරන්නේ. ඒ මිනිස්සුන්ව කොන් කරන්නේ නැහැ. හැබැයි ඒවා ප්‍රොමෝට් කරන්නේ. ඒ ඒෂියන් කල්චර් එක තමයි ඉන්දියානු මනෝත් හරි දෙයක් ජපාන. යුරෝප් රටවල් තාම නැහැ. ස්ට්‍රීට් ඒරියා කිව්වා නේ. තාම කිව්වනේ නෑ. ඒගොල්ලෝ වල වෙස්ටර්න් ටයිප් එක වගේම වෙස්ටර්න් හරි වෙනස් නෙමෙයි. නැමනකොට දැන් ජීවිත සමාවනවා. මේක ඇති. ඒ කල්චර් එක නේද? ජපානයේ එහෙම නැහැ. ඒකත් ඩෙවලොප් කල්චර් එකක් නේ. ඒගොල්ලෝ ඉකොනොමික් ගොඩක් වෙස්ටර්න් කල්චර් වල මොකද ඒක එකක් තියෙනවා නේ. නමුත් they maintain their tradition. The Asian culture in Japan, you know, yes, among the countries that I have visited, I never seen such a clean, pure country. You know, last time I gone on that man, bro. I'm not going to command that right? ජපාන මංගී එක පැත්තක්වත් කටයි කියන්නේ නෑ ළමයි. ඒක ඉරේ කියලා කියන්නේ අරිම පිළිසිදි අරිම. සතුර හැදුනා මේ ලක්ෂ ලෝක කොහෙවත් නැහැ. ඒ දින අක්කර ගණන් සතුරවත්. තුමලක්. You must visit Japan. ඒ ලක්ෂ බාට බඳ යනවා යන්නේ. මම ඉන්දියාවට කැමති නෑ. they are too busy. ඒක මම හිතුවා. අපේ ගැලපෙන්න නැහැ. මිනිමම් නෑ. everything is not දුවනවාමයි. අරින්න ඒගොල්ලෝ දෙන්න ඒගොල්ලෝ තාමස්තර මේ ජපාන් සුත් වැඩ කරන්නේ පරපර බයිනවා. අමුතුරටක් මම ඉතින් අවුරුද්දක් විතරක් මේ මට තාම ජපාන් වලින් 3-4ක් තියන්නත් ඒක උන් ගන්නන්නේ නැහැ. අපේ විදිහට අපි අවුරුද්දක් ඉඳලා ඉන්නේ. අපි ලංකාවේ ඔක්කොම වරුටි මණ්ඩල පොළොව චලනවා නේද? උන් එහෙම කරන්නේ උන් හරි වෙනා. ඒකත් හරි වෙනා. අපි කැලි කැලි කතා කරලා හරි අපි ඇප්ලිකේෂන් කරනවා. ඒක හරි අමුතු જાතියක් ඒක පිළිස්සුකම. ඒකම තායින් බෙච්චා පාසලා නැතේ. ආසයි ලංකාවේ කන්දේ ජපනීස් කුපල් එක්ක. ඒක සුලේමන් පිටි හරිම ලස්සනම කැමක් මම කොහෙවත් හම්බෙන්නේ නැහැ. බත් ටිකක් කෑවත් ඒක අරින්න වෙනවා. වෙනම කණින් බත් කරන්න කිව්වන්නේ. ඒක හරි වෙනස් කරලා. කවුරුත් පිළිගන්නේ මේ බයින්ඩෝනේ ජපානයේ ඉඳනේ ලන්ච් එක හැමදාම කොහෙන් හරි ගේනවා. ඒක හරි සාධාරණ කම්වල ඉස්සරහ කැම වෙනවා. කැම වෙන්නේ සාමාන්‍ය ජීවිතය කියන්නේ ඉන්ග්‍රීඩියන්ට්ස් 150ක් වගේ. ඒගොල්ලෝ වල බෝ එකත් එක්ක they change everything. Even their food style also. Food අපේ බත් පිළිබඳ જાතිය ඒක ඔක්කොම වෙනස් කරලා බත් අඩු කරලා මාළු මාස් වල කරලා හැම දෙයක්ම වෙනස් කරලා right. ඒ වගේම චරිතවලින් තාම සිනෝනායි දාන්නේ මම තාම පාසි වගේ දේවල් සමහර මේවා කරවලනේ අර උඩ බබ්බු තාම කරනවා to respect their tradition. ඉති කාලේ බඩගින්න නිසා උඩ බබ්බු දේවල් තාම අර උඩම වගේ කියනවා මේ කාමෙන් වගේ කියනවා ඒක කැලලක් ගන්න. ඒ වගේ අමුතු ක්‍රියාවක්. මේ කොහොමද ඉතින් මේ පොඩ බොරු කරන්නේම නැහැ. මට හිතා ගන්න බෑ මේ කේස් වල ජපාන් දිනුවා. ඒගොල්ලෝ මේ මන් එකක් කියන්නේ 10000ක් තිබුණා කවවත් ඇහිදින්නේ නැහැ. ඒ වගේම තමයි එන්න එකක් හරි එන්ටයිටල් නම් දුන්න නැත්නම් නේ. right. සාමාන්‍යයෙන් පදේ ලක්ෂ 3 වැඩි දෙක ලක්ෂ 3 වැඩි යනවා. ඉතින් 3 ලක්ෂ 21යි කියන්නේ පදේ අර එකක් තියෙනවා. සහ එකට ගන්න දේවල් ජපාන් තියෙනවා. ඒක තමයි මේ වැලියුස් මනි කියන්නේ. දැන් අපි රුපියල් 7 කියලා තියෙනවා. ඒක ඕනම වටින් තකපෝ. but still we have it නේ. සාමාන්‍යක නැති කියලා නෑ. රුපියල් 7ක්. There's nothing to do with the 10 rupee, but still we have a sales guy. ඒ 7 නෑ yen විතරයි තියෙන්නේ. හැබැයි yen එකක් ගන්න බඩු. අපේ රුපියල් ගන්න බඩු තියනවා. ඒ වුණාට 7 කියලා හේතුත් පිළිගන්න කියලා මොන මංගල්‍යයක් කියලා මම දන්නේ තාම ඉඳ එක චෙක් කරනවා හරි රුපියල් 1552යි කියලා ඔය 7 එක කොහෙන් ගුණාද ලංකාව ඒවත් වෙනස් කරන්නේ නැහැ මේකට නේද මේ සිංහල වලට දුන්නා ගන්න අර වගේ තිබුණාට කවදාවත් නිසින්නේ නැහැ හැබැයි මේ නැහැ කියලා නෑ එහෙම කල්ටි නෑ නේද මේ කේස් එකේ තමයි තියෙන්නේ ඒලා මෙහෙම හරි වෙනස් තමයි I used to work there whether they are the mental management or different man. Completely different. Let's talk about the components of management there. As experience plus. The experience whether I'm the bike thing or something. Whether they did. Pahal now, Pahal car, they have a computer. Pahal car now, top a car. Over ඕදෙනවා ආය ඕදෙනවා ආය කියනවා හතර විතර තමයි අපි ඉන්නේ පැය කාලයක ඒක ඉන්නේ ඉතින් අතව පැය කාලයක් ගාව තව DHP යන්න 1000ක් විතර හම්බෙනවා ඒ ඉන්න වැඩට එන්නේ ඉතින් නෑ පැය කාලයකට ඉංග්‍රීසිවල පැය බාහිරව ජපානයේ පැය කාලයකට මේ ජපානයේ ඉන්නේ නැහැ නේද අපි යන්නේ අපි වලකට කොහොමද දැන් ගන්න පොඩි කරනවා උන්ගේ විනාඩි වැඩම කියලා යනවා මේ වැඩ තිබුණොත් දොලාර ගානක් කරා අපි වැඩ තිබුණත් කරනවා නැතත් කරනවා අපි පොඩි කාලෙක ඉඳලා ඉන්නේ මොනදෝනේ ඒ නිසා මම කියන්නේ මේ වැඩ කරනවා තමයි මේ මම කැම අඳුර කම්පැනිගෙදී එක මැෂින් තියෙනවා හැමෝම එක මැෂින් එකක මම වැඩ කරනවා there's a one person who can work in any machine who is that man you think he is the Sacho, on. Cuman kita lihat bedanya office ke ini saya kodal, pocket kali action එව්වා කරේවා ඒප්‍රිල් එක දාගත්තා ඌ විතර ගත්තා. අනිත් තුන්ට මැක්සිමම් දෙකයි නැත්නම් එක මැක්සිමම් දෙකයි ගත්තා. අයිතිකාරයට ඕන මැෂින් එකක් ගන්න පුළුවන් ඕන දවසක ඒක හරියටත් කරලා වැඩක් කරනවා. ඒකයි මම කියන්නේ පිටුවේ නේ අපේ රට ගන්න කොහොමද නේද? කුරු ටැක්ටර් එකෙන් වැඩ ගන්නොත් අයිතිකාරය. ඒ වගේ කුරු කියන එකකට හදන්න දෙන්නේ. ඒ වැඩ ඒක අල්ලි පිටුවේ කරනවා. පස්සේ ළමයි දෙන්නත් වැකේෂන් එකකට වැඩ උඹ දාන්නෙම භූමි කියලා කියන්නේ කුරු අල්ලි ගන්නයි. ලංකාවේ නම් ඒක ඉඳලා හිටගෙන අපිට එක්ස්පෙක්ට් කරන්න බෑනේ. ළමයි දෙක දාන්නේ වැඩිම වෙලදන ජරාම දැන් තමයි. අම්මා මාත් එක්ක වැඩ කරා. 8+. හැබැයි මේ ඉතල එක කෙල්ලෙක්වත් පේන්නේ නැහැ. ඒ තරම් ඉස්පෙක්ට්. අවුරුදු 80 ගාන මගේ මැෂින් එකේ විනාඩියක එක මැෂින් එකක් තියෙනවා. විනාඩියේ කප්පලේ එකක් කියලා විනාඩියට 60ක්. මේ අවුරුදු 80 මාසෙ මේක විනාඩියක එකක් කරලා අතට පැක් කරලා අන්තර්ගත කරලා තියෙනවා. ඒ වගේ අවුරුදු 80 කොන්නේ කපලා ඉන්නේ නැහැ නම් කියන්නේ බයිසිකල් එකේ අනාතේ කොන්නේ කපන්නේ කියන්නේ පිසුදු සම්බන්ධයෙන් සිද්ධ වෙනවා කියන්නේ. ඒක හැම වයසකම කොන්නේ කපන්නේ සා බයිසිකල් වල තමයි. බයිසිකල් යූස් කරන රටවල් මම ජපානයේ ඇම්ස්ටර්ඩම් වෙලවත් එකේ බයිසිකල් යූස් කරන එක ලොකු ප්‍රවාහයක් නැහැ. අපි කීයේ ඉඳලා බයිසිකල් පදිනවා. දැන් ඉංග්‍රීසි බයිසිකල් අපිට අපිට වගේ ඉන්නේ නෑ. ඒක සිස්ටම් එකක් නේ. අපිට බයිසිකල් වල පාඩම් කරලා ඒක අපිට දාදී දාන්න. බත් දාදී දාන්නත් තුන්වෙනි සමයකේ ඒ වැඩේ කරනවා. ඒගොල්ලෝ බයිසිකල් වල තමයි වෙන්නේ ඇම්ස්ටර්ඩම් වල ගිහලා අසපාට පුතු බයිසිකල් වල ජපානයේ පුරා බයිසිකල් දෙන්න මෙහාට වෙන බයිසිකල් දෙන්නේ. අමතක වගේ බයිසිකල් දෙකක් තිබුණා. මාත් එක්ක අතලදලා කැලේ මට තාම මතකයි. කොලිත සංකේල ලස්සන කෙල්ලෙක්. බයිසිකල් වගේ කෙල්ලෙක් කරේ. මේ කෙල්ල ඉන්නේ පොඩ්ඩක්. මම නම් පොඩ්ඩක් කපු කෙල්ලක්. ඒක මම බොරුවට මේ කෙල්ලෙක් කිව්වා මම ආසයි පොඩ්ඩක් කිව්වා. අපේ ලංකාවේ පොඩ්ඩක් කරන්නේ. බුදුර පොණ්ඩේ ආසයි කියන ඒවාට හැම පොඩ්ඩක් 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 කාලා පොඩ්ඩක් නම් ගන්න. ඉතින් මේකේ ඔෆිස් එකේ වැඩ කරේ දිග පොඩ්ඩක් නෑ සාමාන්‍යයෙන් ජපානයේ පොඩ්ඩක් වගේ ඉන්න ඈ දවසක් මේ කෙල්ල පොඩ්ඩක් පොල්ලේ මගේ ඉතින් මම කිව්වා අපරාධ පොඩ්ඩක් නෙමෙයි. It goes to a church. ගානක්වත් ඒක වැරෙනවා මේ විහාර සාමි කියලා කිව්වා. ගානක් ප්‍රශ්නේ මොකද ඔෆිස් එකේ ඉඳලා වැඩ කරනවා පල්ලෙහ කරනවා. මේ කෑම හදලා ඒකට කෙස් කරලා ඉන්න කැප් එක දාන්න ඕනේ. අර අදිපාතිල කොන්නේ කොල්ල වගේ කපලා කැප් එක දාන්න. ඒගොල්ලෝ එකස් පෙන්නන්නේ ඉන්නේ. ලංකාවේ නම් කොල්ලලු ඉන්නේ. මම ඒක වගේ බලන්න දෙයක් නැහැ නේ. මොන කම්පැද්දද? ඒ වගේ ලක්ෂපාරකට දුක් ප්‍රශ්න කොල්ලලු ප්‍රශ්න දෙලා ඉවරයි නේ. මට හිතාන්න බැරිුණා අර අදිපාත් විතර තියෙන කොන්නේ කපලා කොල්ල වගේ කපලා මැෂින් එකේ ගත්තා කෑම නිසා. yes sir. that's the attitude. කොන්නේ කරේනවා කිව්වෙච්ච ගානක්වත් නැහැ. ඒ වගේ so I learned so many things in Japan. That's more than in my week for 4 years. ඒ වගේ ඉගෙන ගන්න දේවල් කෙරුණා නම් වගේ නේද. so that's by doing it. මට හරියට ඒ වගේ රටක් ගැන මේ කේස් එක කතා කරනවා. Because in this case, Mutual Corporation was the main shareholders, right? So, according to the projected profit, the Hilton Hotel never will reach. Then Nihal Srilanka filed the case. He had 0.1% share. At that time, there were no commercial airport. He filed a case before the Colombo District Court. Colombo District Court accepted the case. Then Mitsui Corporation made an appeal to the Court of Appeal, saying that they are strongly against this petition because we have 35% share. This man only not even a 1%, 0.1% share. So we are strongly against this. So Court of Appeal accepted. The person who has 35% shares don't want to go ahead. But this man only has 0.5% share. That is not fair. So they certify the case. Then Nihar Shyamala filed the appeal again to the Supreme Court. Then Supreme Court accepted that district court was correct. Then permitted the district court to go ahead with the case. The argument was this is a derivative action. Here, Prima facie there is a case. Value ban case Supreme Court decided. Because at that time they realized that the reason that they never received the application profit was 76 rules were missing. Right? And the district court, they have appointed a chartered architecture to find out what happened. Then he realized that 2 floors and 1 basement were missing. Right? 24 floors, 22 floors and 1 basement missing. That was the reason that they never received the project. That includes 74 double rooms plus 2 management funds. Then they never received any unit. That was the case. So, Supreme Court decided here there is a case. Then there is a case. So, sir, derivative action on the derivative action because the wrong action was fraudulent action was done by the majority shareholder. Then they never file a case. Then the case filed by the minor shareholder has to be accepted. And in England, it is recognized as a derivative action. This is decided filed in 1990. At that time, our company law was dependent on the English law. So, court decided English common law was a part of Sri Lankan company law. Derivative action is a part of English company law. Therefore, it is also a part of Sri Lankan company law. Therefore, this case can be accepted. Then the district court just appointed the chartered architecture, and then they ordered the Ministry Corporation to present the original plan of the Hilton site. Where they are replied that all the originals were in the site itself. When there was a fire in 1984, all the originals were burned. Then the court will not accept copies, but however, when there is absence of original, they order the company that there must be some copies. They'll provide your copy. Then their reply was, all the copies also were in the site itself, they were also burned out. Then they asked, you might have some copy in Japan because all the architects, contractors were in Japan, at least give us copy. So they replied that we haven't got any copy in Japan, all sent to the Sri Lanka, all were burned. Then at last, they ordered the Colombo Municipal Council to provide their copy because in Colombo City you can't have any building without their permission. Then Colombo Municipal Council came with the plan which they have approved in 1985. And that was an amended plan. That is what you stand to do. So even until today, no one has seen the original plan of the Hilton Hotel. Right? 2 floors missing, 1 basement is missing. That is why you all have been to the Hilton Hotel. They don't have even enough parking. In a 5-star hotel, you can't have such a hotel, right? The enough parking should be there, otherwise it's not a 5-star hotel. But in Hilton Hotel, that facility is not there. So vehicles are parked everywhere in the hotel, where they could use that space for some other business. But now they use them for car parking, right? Because 1 basement were missing, 2 floors were missing. So then anyway, in between my was expelled from the case settled. It is unfortunate that Sri Lankan government was also a shareholder of this case, and they have provided their own facility. Right? However, what is important for us is that the court accepted the case filed by a person who had not even 1% share. So that's a very good statutory position for the protection of the minor shareholder. Right? So that protection is now there, right? Even though you don't have 1% share, still you have remedy. You can find it. Right? So That's a hit and case. So this is known as the wrongdoer control number. They are persons against whom the belief is sought and they hold the control of the company. It is obvious that they won't file a case. So the company or the business corporation never will file a case because it is done by themselves. Right? That's why I said I can't use that Japanese ever. The people every month and every year. I think more getting a month again as well. So they got one of so happy in the number can do not last it 10%, 20%, however it was done. So everything is started to be not like other than how much, right? Nothing to never make any profit. The land was a lease agreement, lease given by government. They have not paid a lease for the government for years. Right? The loans were not being settled. The company was delisted because they don't comply with the BSP rules and regulations. Right? And how much we are now, then Mandan and saying, it was not again a month. Panda with Margada and without the fire, right? Right. So what is important for us is that so we recognize derivative action even if it is not provided by the contract law. But now from 2007, it is a written law. In 1990, certain case was accepted as a common law remedy, but that is why even the court of appeal rejected it. But now there is no such rejection because it is a recognized right by the Companies Act by Section 234 as a derivative action. But in this treaty law, even a director can file the case, but under the common law only a shareholder can file the case. But here you can see it is not a right because it is not good for the company to let one person to file a case against thousands of people. Therefore, first you have done leave from the you have to take leave from the court to go ahead. But definitely when there is a clear case, court will grant license. Court will leave you to go ahead with the case. Like in different case they did. Right? So, however, when leaving the or granting the leave to hear case, court will look at the steps that the company has already taken, the amount of revenue and the cost of litigation. So, thinking of all those things, court will decide whether to grant leave or not. Therefore, it is not a right, but first we have to get grant or leave from the court. If court decides that there is a case, then court will grant you leave to hear the case, and then you can go ahead. So under this section, if the wrong action or fraudulent action is done by the majority people or the controlling shareholders, the minor shareholders can file a case. What is important is again even one person can file against the company or whoever the majority people or whoever has done the fraudulent action. Therefore, again, a salutary question for the minor shareholder. You can't say the majority, right? When they are structure, recognized rights under the Companies Act. Okay, then so we have discussed some of the recognized rights. We have discussed oppression, mismanagement, derivative action, and the test trading. Two or more remedies that we will discuss in this. Okay, then we will continue this lesson next week. For the last 4 weeks, we will go in the class. What's the time? Okay, then we see you next week. Is your fine? Can I borrow the thing?